Good morning. Welcome to the first in a three-part series of webinars offered by Weingartner Law. We are reaching out to financial advisors and financial professionals to share our information about how our team, our estate planning team specifically, can partner with you to help you get and keep assets under management. Today's talk is going to be focused on special needs trusts, which is a tool that as financial planners you will want available to you through your estate planning partner. The Weingartner Law Firm has brought on board Lisa Finn, who is an estate planning attorney who's going to be heading the talk today, and I'm going to hand it over to Lisa.
Good morning, everyone. I am so happy to be here with you today to talk about supplemental or special needs trusts. I'm attorney Lisa Finn. My law practice focuses exclusively on estate planning. Since 2014, this is all that I've done. And I have to say that I specifically enjoy this type of planning the best. So without further ado, let's go ahead and dive in. Our agenda today is big. Why plan? What is a special needs trust? What does this have to do with Medicaid? Keeping assets under management, the estate planning team. So why plan? What are we doing here? What are we trying to do? We are trying to protect assets, protect wealth that you are managing. What are we trying to protect it from? Depletion. How? We're trying to do so by protecting your clients' children or your clients themselves, their eligibility for governmental benefits, and at the same time protecting the assets inside of the trust from creditors. Special needs planning is so important. I hear all the time people trying to figure out ways to maneuver the system, specifically by disinheriting a child because he or she has a disability and they know that their future inheritance will be used against them for purposes of governmental benefits. Oftentimes, they want to send one child's inheritance to another child. They're relying on their brother or sister to dole out money for the benefit of the person with the disability. This is one of the worst ways to go about planning for your eventual departure and planning for your children with disabilities. There's a lot of reasons why I could go into why this is a poor way to do it. Another thing that you're doing when you're proactively planning with trusts is you're protecting that disabled person's, probably child, protecting their privacy. If things go wrong, when things blow up and you need court intervention, it becomes public record. Avoid costly mistakes. As an estate planning attorney, I often hear, oh, estate planning is only for the super rich. Let me disabuse you of that notion. Here, more than anywhere else, your clients, your regular people that you work with can't afford to make a costly mistake. Super wealthy people can. Your clients cannot afford to make a mistake. What are we trying to protect? We're trying to protect Medicaid and SSI. And the question is, are we trying to protect it right now? Does this person already receive SSI and or Medicaid? Or is there a future possible need for it? What are we trying to protect? Once again, Medicaid and SSI. Medicaid and SSI. Medicaid is for people that have low income and low assets. SSI is the same thing. Medicaid and SSI are needs-based governmental benefits. What we're not worried about is SSDI or Medicare. SSDI is disability income based on one's work history for people that are under 65. And then Medicare is health insurance for people that are over 65 or possibly in some certain circumstances under 65 but disabled. SSDI and Medicare are not needs-based. We're also further distinguishing between people over 65 and people under 65. And we're making that distinction because we're required to. The rules that we're working with make that distinction. Going to go ahead and tell you right here, for people that are over 65 doing this type of planning, supplemental needs trusts do not work. They have to work with pooled trusts, which by definition means they are not under your management anymore. So we're talking about supplemental or special needs trusts for people under 65. And of those supplemental needs trusts, there's two more distinctions to make, whether it's a first-party trust or a third-party trust. We're going to start with the first-party trust or the self-settled trusts, and as the name implies, they are set up by that disabled person, him or herself, with his or her own money. Every trust, every supplemental needs trust is for the sole benefit of the disabled person. But once again, this is that person's own money that they are now distancing themselves from and placing it in trust. Typically, in this scenario, this money came from a personal injury settlement. They had a huge accident and they were permanently disabled. And as a result of that accident, they got a big settlement. Also, it's typically from an inheritance. So an inheritance or a personal injury settlement. First-party supplemental needs trusts have a payback provision. If you set up a trust for your sole benefit, at the end of your life, that money, whatever's left inside of that first-party supplemental needs trust, must go to the state. It must be used to pay back for those governmental benefits. What's your role with first-party supplemental needs trust? You need to be able to see this problem. You need to tell your client that just got the inheritance or just got the personal injury settlement that they should consider the supplemental needs trust, again, in order to protect that wealth, protect it from depletion. You need to work with an attorney to create an appropriate plan, and then you need to continue to invest and manage those assets to grow wealth for them. Who can serve as a trustee of a first-party supplemental needs trust? Anybody but the beneficiary, him or herself. So it can be a parent, a grandparent, a legal guardian, a court-appointed trustee, possibly you as the financial advisor. It can never be the beneficiary, him or herself. Now let's talk about a better trust, a third-party special needs trust or supplemental needs trust. This is set up with someone else's money. This is proactive planning. You know grandma wants to leave money to grandson, but you know that if he gets that money, he's going to lose his benefits. Instead, grandma should set up a third-party supplemental needs trust. It's set up by somebody else to maximize governmental benefits. It can be set up through the will. Grandma can say whatever, $50,000 or whatever it is, goes to a supplemental needs trust for my grandson. Or grandma can today set up a supplemental needs trust, a living trust, one that's created while she's alive for the benefit of her grandson. Third-party trusts can be set up with all types of special provisions to truly get the best that your clients and your clients' children deserve. Care managers, I spoke earlier about you being the trustee possibly. You might not know everything likely you don't know everything you need to know about these specific disabilities that people are suffering from and the best treatments and the best things that are out there today. You want a care manager. You want to work with somebody who knows the best practices today and moving forward. You want flexibility in the housing provisions, and you want to specifically say with this third-party trust where the money that's left in trust at the end of the beneficiary's life or at the end of the trust, it might not last the entire lifetime. Where does that money go? Again, because it doesn't have to be paid back to the state. Third-party trusts can terminate upon the death or of the disabled person. And again, the assets can go to somebody else, to a charity, to another child, whatever you like, but again, not pay back to the state. Here, once again, who can be the trustee? Anybody but the beneficiary, him or herself. It can be a family member, it can be a friend, it can be a professional trustee, it can be a financial advisor. Choosing an appropriate trustee, however, is one of the most critical parts of supplemental needs trust planning. You want to ensure that he or she understands the scenario, the paradigm in which we're operating. You want the trustee to be organized, good with money. Most importantly, you want them to be open to seeking out professional advice. We said we want them to understand Medicaid law. I mean, that's huge. That's a huge thing to ask of an individual. You need them to be willing to be coached, to be trained. You should absolutely consider a professional trustee or co-trustee. Again, why we call it a supplemental needs trust is because it's supposed to supplement, not supplant, the governmental benefits. These governmental benefits that we're talking about are needs-based, and if the money in the trust could be used to supplant it, then that beneficiary no longer needs the governmental benefits. So again, we're talking about using the trust funds for specific described allowable purposes so that we are supplementing, not supplanting, the governmental benefits. Within that trust, you can put life insurance proceeds. There can be annuities. There can be other types of investments. Hopefully, all kinds of new vehicles will be coming down the road. There is no reason to think it just has to be cash inside of these trusts. Different vehicles can absolutely be inside of these trusts. The name of the game is keep these assets under management. You continue to manage them for your clients and for your clients' children, grandchildren, etc. With trust-based planning, you are protecting wealth as best as you can. You are protecting it because you're offering you're protecting the eligibility for governmental benefits. You're protecting against judgment creditors, and you're protecting that wealth so it can continue to grow. With a third-party special needs trust, there is no payback provision. Again, this is about allowing your clients to feel safe and secure. They are concerned. If you are working with people that have a disabled child or have a brother or a sister with a disability, you know how much stress they're under. You know how worried they are about who's going to care for their loved one when they no longer are there to do so. And not only who's going to care for them, with what? How do we make sure there's enough money that this person who may never work and may have serious medical expenses, how do we make sure that there's enough for them for the rest of their lives? This is a great way for you to open up a conversation with your clients. Again, this is just, it's another entrance for you. I would think you probably know if your clients have a disabled children, but this kind of conversation can be brought up in terms of talking about long-term care insurance or disability insurance and speaking to that. And then they might tell you, oh, my brother or my sister or my brother-in-law or my sister-in-law. So this is just sort of a kernel of information for you to take with you into your practice. The team, the dream team, you need to work with attorneys. You need to work with attorneys to draft these documents. And you need to work with accountants because these are trusts and it might not be, I'm not saying it's a terribly complicated, but the trust is an entity and it's going to need trust accounting. We're going to ask you, don't quote fees. Of course, don't give legal advice, but do share ideas. Nobody knows everything, and especially since you know the clients and you know their loved ones, feel free to bring up ideas that you may have. Thank you so much for your attention this morning. We hope you enjoyed Supplemental Needs Trust Planning, Keeping Assets Under Management. There's my information. You can always email me with questions or comments, lfin@weingartnerlaw.com. We're going to pass it back to Jennifer. Thank you.
Thank you so much, Lisa. That was really informative. Thank you for coming to our webinar this morning, or logging in. We're going to have a recording of this, and we'll put the slide deck up on the website so everybody can access it at some point. This is the first in our 3-part series of Keeping Assets Under Management. We look forward to bringing you next month a small discussion on wealth planning for women. And down the road, we're going to talk about new tax laws and tax cuts. The Weingartner Law Firm is building our team in order to help people build their family, their foundation, and their future. And we believe that partnering and linking up with financial professionals is just another layer to the dream team that can help people do that. So stay tuned. Thank you for tuning in, and check back on our website for the recording.